I am very excited about this next session. When Pasquale and I were talking about the design of the program, we just really felt that we needed to hear from the judiciary. And I am just really thrilled that we have a group of members of the judiciary from very different parts of the world. And I'm just going to introduce our moderator, and she can take the panel away. But Tamara Ashford, Judge Tamara Ashford, I'm so glad to have her as our moderator of this conversation. So, Tamara.
Thank you so much, Nina. Although I guess it's a little funny for you, so you're very, very excited to hear from us. Hopefully we will meet your expectations. Good late morning, everyone. Yes, as Nina said, I'm Judge Tamara Ashford of the United States Tax Court. I am very pleased and quite frankly honored to serve as the moderator of this panel with several esteemed colleagues of the judiciary from several different countries this morning. So let me, without further ado, let me introduce them. To my immediate right is the Honorable Chairman Anthony DJ Gafour, Justice with the Tax Appeal Court of Trinidad and Tobago. This court, we will, a little bit later or throughout our conversation, we will sort of go into some detail comparing our courts. But I will say that his court is a superior court of record and mediation agency, very similar to the United States Tax Court. To his right is my colleague on the United States Tax Court, Judge Mark Holmes. Mark actually, or Judge Holmes, excuse me. I have to remember where I am. He actually, I guess it was last year, finished his first term, 15-year term on the court, and has been renominated by President Trump to serve a second term. Hopefully, we're all hoping that he will actually have a nomination hearing soon. To his right is the Honorable E. Young Lee. She is the High Court judge on the Seoul High Court in South Korea. And it's my understanding that that court is very similar, at least from the United States perspective, of like a federal circuit court of appeals. And she will talk more about her court and where that fits in her system. Our full bios are in the materials. And so I will say that I know, recognizing that we're pretty much standing in the way of you all having lunch, over this next hour or so, we hope to engage in a robust and interesting conversation about our respective roles in 1, protecting taxpayer rights, 2, ensuring transparency and consistency of government actions, and 3, increasing access to the courts. And so indeed, we hope this will in fact be a conversation. I will be posing lots of questions. I'm happy to take questions from the audience throughout, or you may wait to the end. But I will say that at the outset, Judges Gafour and Judge Lee have prepared and will present in a few moments part of short papers that they have done on these topics. And the U.S. perspective on these topics will actually be incorporated or weaved throughout our conversation this morning. So I think with that, without further ado, Justice Gafour.
Thank you very much, Tamara, and of course, very delighted to be here, and of course, just to share a few thoughts with you on the work and the role of the Tax Court of Trinidad and Tobago, which has been deemed in some ways the preeminent tax court for the region. Now, it's been said that, and you may probably know this adage, that a fine is a tax for doing wrong. But on the other hand, it's also been said that a tax is a fine for doing well. So from that perspective, one might understand that while I'm going to touch on some new initiatives that are being brought in tax-wise, it's probably also true to say that no new tax goes unpunished. So I want to start off by talking a little bit about the background to the tax code of Trinidad and Tobago, and you should have the synopsis in the information pack. But essentially, it's a small island developing state which and of course a former British colony, which gained its independence some years ago, back in 1962, and subsequently became a republic in 1976. So the links with Britain have continued to be fairly strong, and as a result, that has tended to govern the jurisprudence of the court over a period of time. Similarly, in terms of the cultural factors, I've given you a short account of the mix of persons there roughly. So we can see that it's a very mixed population, one that in fact has spawned a number of challenges in terms of how the court and the judiciary generally deals with such matters. And then, of course, in more recent times, we had a fairly significant influx for a relatively small country of people from Venezuela. Now, over a period of time, there has been significant connections between Trinidad and Tobago, which is just about 13 miles away from Venezuela. But we've had a number of immigrants coming in, both documented and undocumented. And that in itself, I think is likely to cause future issues to arise, particularly in the judicial system. Coming out of all of this, and the reason for talking about this mix is the fact that we have, as you will no doubt understand, a variety of different cultures, many of whom prefer to not necessarily settle matters through the court system. And when I say that, I don't necessarily mean through some acts of violence, but certainly in terms of looking at ways in which they can resort to more traditional forms of dispute resolution. And in many cultures, that has tended to focus on perhaps asking elders or other respected members of the community to intervene and to resolve disputes. But certainly in more modern times, one understands that there's a reference to utilizing the court system by way of trying to resolve matters, whether they be tax disputes or otherwise. Now, certainly all of these matters, particularly in colonial times, were dealt with by the colonial authorities, and there's a whole raft of cases going back to the 1930s and others dealing with much of the same issues that the tax court deals with at present. However, it was established as a Superior Court of Record in 1966, and since then, of course, deals with a variety of different taxes. Now, it also has tended to have a high preponderance of energy-based cases. You have a whole range of multinational companies that have operated in the region over several years. And as a result, a lot of the disputes that have arisen have been fairly large-scale matters, energy disputes involving oil and gas issues, where sometimes arbitration is used as an alternative to the court system. But also, of course, as you can well imagine, these companies tend to bring in the big guns when it comes to dealing with certain matters. But I'm also happy to say that, one of the things the court has been doing is to try to encourage processes to assist litigants who may not be able to afford that kind of pristine litigation representation. And of course, we've also been looking realistically at the use of ADR to help resolve disputes. Now, one of the factors that I think it's important to situate the court in is that it's part of something called the Caribbean Single Market and Economy. And that, as with the European Union, requires certain undertakings by governments, especially with the free movement of certain persons, goods, services, and so on. And that in itself, of course, has also been problematic because we're seeing people not just home-based, but from a variety of different countries coming before the courts. And that has given rise to some cultural challenges. So what I want to focus on principally in my very short presentation would be some of the new legislative measures that are being brought in by the government of the day. And the first one that you may see mentioned here is a new property tax. Now, this had traditionally been dealt with by the tax court in the past. But I think what is a little bit troubling is that the government has sought to establish a tribunal under the control of the relevant minister, Minister of Finance, to value property. The implications are fairly severe in the sense that a lot of the landholding is done, or is really kind of, land is held principally by members of the Eastern community as well as the Syrian community. And it may be that unless you have sufficient safeguards in place, this can be a little bit problematic. And of course, it's going to impact on the court in terms of protecting such taxpayers. Similarly, because of the growth of online commerce, and again, tapping into the revenue that probably can be generated by this, a 7% tax was imposed, but again, without recourse to the possibility of challenging that. And I think this also has been an issue for the court in terms of how to deal with such an issue. And then, of course, what is also being proposed is the creation of a revenue authority. Now, you have this in Britain. You have this, in fact, in some of the other islands, such as Barbados and Guyana. One of the challenges here, though, is the extent to which there are insufficient safeguards for the exchange of data, particularly between the customs and excise and the revenue, inland revenue. So I think that is an issue that, again, the court will have to grapple with in due course. And then again, one issue that you see fairly common to many jurisdictions is the application of double taxation treaties, particularly when it comes to exchange of information agreements. And one of the peculiarities of the Caribbean has been offshore banking, when this has been a significant growth area, particularly for small economies that may not be blessed, shall we say, with a huge variety of resources. So from that perspective, of course, we know the OECD has been concerned about issues of anti-money laundering measures and trafficking and so on. But at the same time, I think that one also has to be careful in understanding that I think most of the Caribbean countries are not necessarily going to be endorsing any kind of illegal activity. But having said that, in terms of being able to stand up to bodies like the OECD, that can be a little bit problematic as well. So what is the court actually doing to protect taxpayers' rights? Well, I've identified a few measures here, some of which perhaps are common to many other jurisdictions, but one or two others perhaps may be different. So certainly one of the things we try to do is to ensure that taxpayers can carry out sufficient research when they need to prepare their own cases. And because our proceedings are in camera, we also try to ensure that cases are published, especially by ensuring that those issues of principle can be brought to the attention of taxpayers at large, particularly when it comes to issues which may arise in terms of dealing with personal issues and so on. And then we also try to publish annual reports. We have a special first sitting of the court where we interact with the general public and the media. And then, of course, other activities as mentioned here as well, too, particularly the publication of brochures and newsletters more recently. So I think in all of these steps, what we're looking to do is to ensure that taxpayers at large, particularly those who may not be able to afford legal representation, have that opportunity to be assisted by the court as much as we can. Obviously, there are constraints in terms of how the rules can be applied, but having said that, I think that many of the issues turn on information deficits, and that's one of the things that we try to address in the work of the court. So other current initiatives focus on seeking an update to the legislation. This has been pending for some time, but particularly given the theme of this conference, the e-filing of documents. Because that has been very slow, what we did recently was to issue a practice direction, which requires all submissions, all pleadings before the court to be filed electronically, and that has helped to expedite the delivery of decisions. We also are able to tap into the broader civil proceedings rules in force in different versions in many other Commonwealth countries. And I think that enables us to access not just the rules and practice of other jurisdictions, but particularly where those rules are being developed in such a way as to assist self-represented persons. And unlike the US, which I gather has tended to be fairly, I mean, if I may say so, inward-looking in terms of using your own jurisprudence, the court itself being emanating out of the Commonwealth has tended to draw on wide jurisprudence, not just from South Africa, where hopefully we will be next year, but also Canada, India, New Zealand, and to a much more limited extent, the US. So essentially, what I've tried to do in this brief presentation is just to outline roughly what we're looking to do to protect taxpayers. And if I can just end with a few short other notes, and which is that we're looking to also establish something called an APEX system, which is a homegrown system from the region, which facilitates the e-filing of documents and also issues receipts when documents are filed. And now I know that may be standard in Canada and the US, but it's something that is new to the Caribbean, and hopefully it is something that's going to help parties in terms of not having to necessarily file hard copy documents. We've also got some very modern technology where proceedings are recorded in real time, both audio and visually, as well as the traditional transcriptionists. And then in addition to all of that, we have established a database of judgments which are accessible to everyone, subject to excising or removing the names of the parties unless they permit us to do so. So hopefully these measures, albeit small, are going to continue to have the court enjoy its position as the most advanced tax court in the region, and particularly because it's an important region for commerce generally, and certainly in relation to North America. So in closing, and I'm sure that we'll have some other questions, I particularly want to acknowledge my thanks to the organizers for inviting me to come to this conference. I thought that I was fairly passionate about what I do, but when I met Nina, I realized that my enthusiasm somewhat pales in comparison. But nevertheless, I understand that she is quite surprisingly going to be retiring at the age of 25 soon. So anyway, with that, thank you very much.
Thank you. Yes, I think no one can hold a candle to Nina.
Oh, yes.
Judge Lee, would you like to provide some introductory remarks on our topics?
Yes.
Thank you.
First of all, please understand there's no slides. So, thank you very much for
Oh. Or the handheld. The handheld would be great. Thank you.
You here? Okay. So I'm from Far East, Seoul, South Korea, and then it's about 1 a.m. past 25 minutes in Seoul. So it's it's a long journey from Seoul here just to attend this conference, and it's for me the first time in here, and it's truly inspiring. I just like to give you a glimpse view about the role of the judiciary in protecting taxpayer rights in Korea. Korea has a very long history. 3 old kingdoms flourished from BC, as some of you might know, with unique culture and language. But the modernized judiciary began in 1948 when the Constitution of the Republic was established in a way guaranteeing judicial independence. In spite of relatively short experiences of modern judicial system, the excellence of Korean judiciary has been recorded in various international reports, such as the Rule of Law Index by World Justice Project, etc. The court proceedings reviewing the legality of actions taken by the administrative bodies are another exception of this rapid development. In 1998, the Seoul Administrative Court was established, reflecting the increasing numbers of the lawsuits against government actions. More than 1,000 tax cases are being heard by judges every year, and the courts frequently conclude in favor of taxpayers. not only substantial aspects, that is, whether the taxpayer has the obligation to pay the taxes according to the provisions of tax statutes, but also the point of the due process plays an important part in the court proceedings in Korea. In particular, after the formal recognition of taxpayer rights in Korea was announced in 1996, the judiciary has delivered a series of important decisions that consistently observed that tax authorities should stick to the statutory rules for transparency of the process and for protection of the procedural rights of taxpayers. I would like to talk about this a bit more because it highlights the importance of access to justice and the role of the judiciary in promoting the transparency of the tax administration. In December 1996, the Basic Act for National Taxes newly inserted Chapter 7-2, named Taxpayer Rights, and several articles under the chapter, which went into effect from July 1997. Accordingly, the Bill of Taxpayer Rights was published in July 1997. This went along with Korea's joining in the Organization for Economic Cooperation and Development. The constitutional ground for the judicial review and the tax investigation can be found in Article 12.1 of the Constitution of Korea, which stipulates that all citizens shall enjoy individual liberty and no person shall be arrested, searched, seized, or interrogated except as provided by Act, and also the Article 23.1, which provided that the right of property of all citizens shall be guaranteed, and the limitations thereof shall be determined by Act. We have constitutional code separately, which was established in 1987. And the Constitutional Code of Korea held that the provision above applied to any governmental actions as well as criminal proceedings. This decision was delivered on December 21st, 1992. So there was no immediate change since this enactment, but taxpayers and their legal representatives began to submit their arguments based on this new chapter. And as far as I remember, it is from around the year 2000 that the validity of tax investigation became a hot issue in the tax proceedings at the court in terms of the procedural legitimacy. The most frequently mentioned provision is the Article 81-4 of the Basic Act for National Taxes. So here I just read. Article 81-4, prohibition of abuse of right of tax investigation. Paragraph 1, any tax official shall conduct tax investigation within such minimum limit as necessary for appropriate and fair taxation and shall not abuse the right of tax investigation for other purpose. Paragraph 2, tax officials shall not reinvestigate the same affairs of taxation within the same taxable period except for any of the following cases. One, where there are obvious evidences confirming a suspicion of tax evasion. Two, where investigation of the counterpart of a transaction is necessary, and etc., etc. As seen in its title, it clearly prohibits the reinvestigation of the same affairs within the same taxable year. Most disputes have arisen regarding the interpretation of the second paragraph, that is, whether it constitutes the duplicate tax audit and whether it falls within one of the exceptional categories. In a number of cases, the courts, the Seoul Administrative Court as the first instance, and the Seoul High Court, the second instance, and finally the Supreme Court of Korea decided that these exceptions should be applied very restrictively in light of the object and purpose of the statutory provision for the protection of taxpayer rights. This judgment was handed down on December 23, 2010. The Supreme Court declared that the abuse of tax investigation must be prohibited, and the materials obtained through the illegal investigation should not be used for the imposition of a tax under the constitutional principle of due process. This important decision was handed down on December 5th, 2016, very recent one. The decisions of the judiciary are highly respected and followed by tax authorities. Therefore, even if a taxpayer turns out to be liable to tax in substance, the tax assessment would be cancelled by the court decision if it derives from the illegal duplicate tax investigation. It is for the fairness of administrative dispositions and the protection of taxpayer rights. This is how the code emphasizes the rule of law and induces the tax authorities to comply with the procedure rules. Now, it is widely accepted that the judicial review and the procedural legitimacy effectively contribute to preventing the abuse of power and protecting taxpayer rights. A lot of academic articles have been published about this achievement and future goals for more improvement in Korea. Thank you for listening, and I do hope this story was helpful for further discussions with this panel.
Thank you. Now let's see if I can do this. I'm not tech savvy at all. I will admit that. Thank you both very much. You've given us a lot to talk about and to explore further, which we will in a minute. But I thought we would first spend a little bit of time talking about the independence of the judiciary. It's interesting. I came across a great quotation from the late United States Supreme Court Justice Rehnquist, who stated that an independent judiciary is the crown jewel of our system of government. And so what does that mean, having an independent judiciary? I think one definition is that the forum, i.e. the reviewing court, is independent of the taxing authority and fully able to impartially find facts and render opinions as to the law without interference. So I think for sure an independent judiciary is a necessary element to protecting taxpayer rights and ensuring a transparent and fair judicial process to taxpayers. I will say, does anyone, or maybe I know my colleague, Judge Holmes, do you want to comment on this before I pose some questions?
Well, I think a part of the independence of judiciary means that our decisions are reviewable only by higher courts. They're not reviewable by the IRS. Moreover, they can be overturned. By legislation, of course. Tax law is a conversation between the legislature and the judiciary. Only by general rules, prospective in effect as a general rule. What that means is that if the decision in a particular case shows a gaping loophole in the tax code, it can be fixed, but it can be fixed going forward, usually. That also guarantees that taxpayers have a right and they won't be subject to having decisions in their favor reversed by legislation. The same goes in a system which in the US is so heavily geared towards regulations that overturn court decisions. That's a very contested area in American law right now. But as a general matter, our rules are prospective only. And judicial decisions for a particular taxpayer are going to be enforced in his favor. Independence of the judiciary also means that you have an impartial tribunal that is guaranteed almost everywhere in the world, as best I can tell from dinner time conversation yesterday, by some form of tenure in office for judges, some form of compensation for judges that guarantees that they won't be subject to government control. And we certainly have that in our country. In effect, even though I have a 15-year term, I get paid for life, so it makes me more independent and less likely to be a lackey of the IRS. Can you think of anything else that guarantees our independence, Judge Ashford?
Not so much. I would like to hear from our colleagues, Judge Gafour and Judge Lee, regarding the appointment process, your tenure on the court, and perhaps make any comments regarding an independent and impartial judiciary.
Thank you very much, Judge Mara. I mean, one of the issues that I think has been characteristic about the Tax Code of Trinidad and Tobago is the fact that only the head judge or the chief judge is tenured for life. So similarly to the US court or the Canadian court and so on, that is enjoyed in common. However, the other member judges of the court tend to be appointed for a 3-year term through a process of the cabinet making a recommendation to the president. Now, the problem with that is that can sometimes be difficult when it comes to the ongoing issues of litigation as well as the delivery of decisions. So it's a process that I think does need to be reviewed, and it is something that I think doesn't make for a comfortable enjoyment in terms of the process of delivering decisions, particularly when decisions may go against the state or may go against the government of the day, and the danger that that can pose in terms of someone not being reappointed. So certainly it's something that I'm a little bit uncomfortable with, and I think really does need to be looked at.
And do your judges, do they simply apply? How are they sought out to be appointed?
So
do they face any kind of difficult political questions?
Yeah. The chief judge is appointed through a process of application and interview, and sometimes background checks are done. And more recently, a number of psychometric tests are also carried out to ensure I suppose, some degree of stability, as well as, of course, being interviewed on issues of one's temperament and integrity and issues of that sort.
Do they test your intelligence?
Well, that's a very good question. I'm not sure I should comment on that.
Well, Briggs-Myers personality.
Absolutely. But the other members, of course, are drawn from a variety of different strata. They can be lawyers, they can be accountants, they can be people who have some exposure to property issues or valuation of property. But I think even so, we've had some issues there. I suppose the saving grace is that the chief judge's word is final on issues of law. So to some extent, that provides some degree of a safeguard, of course, assuming you get it right.
And Judge Lee, if you could just provide perspective with respect to Korea, the appointment process, say for your court or even any of the other courts.
Okay. In Korea, all judges except the Supreme Court justice are appointed by the Chief Justice. And following the deliberation of the judges' personnel committee, it's kind of appointment committee, and with the consent of the Council of Supreme Court Justices. And then for the further stages, like a test like this, we have first we need to apply what the documents, and the second is the exam. Actually, we have an exam. So it's notorious. We have exam all nationwide basis. So we require minimum 5 years of experience as a legal professional, and then we have an exam for both in the civil and criminal judgments writing exam, and also personal interviews, and then it's decided by. And the Chief Justice and the other justices of the Supreme Court are appointed by the President of the Republic with the consent of National Assembly. But for that, the Chief Justice has the constitutional right to recommend every candidate of other Supreme Court justice to the President. And the President of Korea never, it always, without any exception, follows the recommendation of the Chief Justice. So the Chief Justice have the initiative for the application process, the appointment process. And the term of the office, the Supreme Court Justice, they have just 6 years, very short, and then of the other judges have 10 years of tenure. And whereas the Chief Justice can only serve a single term, and other Supreme Court Justices normally leave after their first term before the retirement age of 70, the judges of the High Court, District Courts, and other special courts can serve until their retirement age of 65, unless they fail to meet the minimum qualification for reappointment. For the reappointment, there's no exam. just click the internet through the click. Very easy, and then no interviews, just a notification, the electronic notification. So we are successful like this, and 99% successful.
Thank you so much. Judge Holmes, since you were actually going through the reappointment process?
I can testify that there's certainly no intelligence or mental stability requirement for American judges.
Oh my goodness.
I'm evidence of that. In the American system, of course, judges are nominated by the president, and the appointment is confirmed or not confirmed by the Senate. In tax court world, they are renewable, but we do go senior at 70. Our pay is unaffected, and it's for life, so we don't have to worry about that, and we're not subject to government control through threats to our livelihood. But the system in America is political. I suspect the system is political everywhere. It's just that the appointing authority, as I learned in South Korea, is by a chief justice. So you have to be political with him. If it's by the cabinet in Trinidad, you'd have to be political with that government. Here you have to be political with the president's party, at least for your initial appointment. Reappointments are by tradition and custom, somewhat like what Judge Lee described. If you don't tick off the bar too much, you'll be reappointed. But political selection in the American system means that you have a body of lawyers who are interested in becoming judges, but they do have to do political work, typically, for one party or the other. They have to appeal to elected officials to put them forward to the people that the president delegates his recommendations to. It's a very different system than I've encountered elsewhere in the world. On the other hand, once you become a judge, you have to abjure from politics entirely, especially elective politics. And then once you put on the robe, you have to treat everybody impartially. And there's a strong cultural component to that, that you don't show favor to anybody on political grounds. So it's an unusual system, judging by what I've seen in other countries, what I've learned about in other countries. But it's been our system for quite some time.
And Judge Trump, that's a good segue to the next question, which is, if you could talk a little bit, what is the relationship, of our court with other parts of the government?
Oh, you know that I disagree with the majority.
Yes, I know.
By statute, the tax court is not part of the legislative or executive branch. There is an ongoing dispute about what that exactly means, since we have only 3 branches in America. And the third branch is the judiciary, but that's characterized by lifetime tenure and a constitutional right to be paid for life, which tax court judges in the U.S. do not have. There is actually a decision from one of our appellate courts that says we're part of the executive branch. It's just that we have unusual tenure in office and an unusual web of statutory protections that make us look very, very much like a court. I won't say anything more than that for fear of ticking off the majority of my colleagues.
Yes, at least we know by statute, I guess passed in
By
2015,
statute,
right? By statute, at least we know we're not an agency,
That's
and
right. We're just
we
like
are
Amtrak.
independent of the executive branch.
And we're just like Amtrak in that regard.
Yes. Judge Gafoor and Judge Lee, would you like to make any comments?
Yes, certainly. Well, I think the system is very similar in terms of the separation of powers between or among the judiciary, the executive, and the legislature. However, of course, one would understand that there has to be some contact, some relationship that exists. And that relationship can be fairly precisely defined. In terms of the executive, it would be principally with the Attorney General, and particularly in terms of the conduit to cabinet for notes and for other business of the court that might need to be endorsed and supported financially by the government. But apart from that, there really isn't perhaps any degree of significant contact with the executive. With regard to the legislature or parliament, again, their role vis-a-vis the court would be principally to endorse or to support legislative amendments to the existing act and rules. And that has been a little bit slow in coming. So as a result, we've had to rely principally on what we can do internally, such as the issue of practice directions to bring in and to enhance the approach to technology, to utilize technology in what we do. But there isn't any other formal contact with the other branches of government.
That's a very interesting point, because budget is the lifeblood of any government agency. And I should mention that there's an obscure provision in American law that guarantees the tax court the right, together with other independent agencies and commissions, to submit their own budget request, our own budget request, to Congress, unreviewed by the executive branch, by the President's Office of Management and Budget. And so it's interesting, is your Attorney General a member of Parliament, or is he a career civil servant?
He is a member of Parliament, and in fact, that has been an issue over a period of time, the extent to which the post holder should be a little bit more apolitical, but generally speaking, is nominated by the Prime Minister as the head of the executive. So that can be a little bit problematic.
How is your budget done?
Yeah, but then we have inside the judiciary, inside the Supreme Court, we have a special minister. He's called the Minister of the Code Administration. So we have, inside the judiciary, we have that one. So he is in charge of the budgets and then submit to the parliament. And of course, we need the approval by the parliament. But anyway, he makes the drafts for the. And then by the constitution, Korea is the country with separation of powers. And then as I explained earlier, we both the government and the politicians in the parliament have no play in the appointment or promotion process of judges, which is done entirely within the judiciary, except the appointment of justice of the Supreme Court. It is really, actually, it's political, as you describe it.
Right. Okay. Excellent. And let me ask you, Judge Lee, how does your court fit within the general court system in your country? Because it's also my understanding when I was doing some research and also looking at your papers, there is in fact there is a tax tribunal.
Yeah, we have a tax tribunal inside the tax, National Tax Service. And we have a sole administrative court as the first instance. And the High Court is Court of Appeal, and the Supreme Court. So we are.
But your tax tribunal, it's affiliated with the taxing authority?
It's
separate
it's quasi,
just like our court?
No, it's different because they are actually inside the national tax system, but they have some panel of consisting of practitioners and academics. So they want to make some very objective and then some quasi adjudicative body inside the one, but it's not exactly like the tax code here. But I think it's more similar to the administrative code. It's more similar with yours, as a first instance, because it's truly a judiciary, part of the judiciary, so it's a difference.
And if a taxpayer has a grievance with the tax authority, they would appeal first to the tax tribunal.
First to the tax tribunal first, you should go there.
Court.
Yeah, and then to go to the code, administrative code, and then appeal. Right. If you are unsatisfied.
And with your court, is it appeal as of right? Or certain you can only appeal legal issues? What about factual issues?
Appeal to the High Court is a right. Yeah. So then you can bring any issues regarding facts or regarding the law, but the second appeal to the Supreme Court is limited to the point of law. And then the Seoul High Court is the biggest in the country, the High Court, and it has several specialized divisions inside the court. It's dealing with some civil cases panels and the criminal case panels and the tax case panels like this. Yeah. Okay.
Thank you. Judge Kafour?
Yes, thank you very much. Well, although it's called the Tax Appeal Court, it really exercises, in effect, an original jurisdiction in terms of being a trial court. So therefore, of course, we hear evidence and we give our judgments and rulings depending on which approach the parties would like to use. But ultimately, parties can have recourse to the court without seeking leave. We have given pronouncements which suggest that the process which should take place below us, which is at the administrative level, should really be characterized by what we refer to as a quasi-judicial process, so that we would expect some degree of fairness to obtain. But even whether or not that has occurred, the point is parties can always appeal to us. And then from this court, an appeal can only lie on a point of law to an appellate court and ultimately to the Privy Council in London. So we still subscribe to the Privy Council as the ultimate domestic court, albeit situated geographically elsewhere.
And Judge Kafour, very interestingly, what deference does your court give to the administrative body below?
Well, I would say none at all. In fact, in the sense that I think they often think we probably tend to side more with the taxpayer. But I think generally speaking, if you look at the litigation that has emanated over the 50-odd years that the court has been around, I think it's been almost 50-50 in terms of how the litigation goes. There are times when, taxpayers in person especially, or litigants in person, do try your patience to some extent. But having said that, we also understand that they may be encumbered by not being fully cognizant of the rules and regulations that pertain to the conduct of appeal. So we try to be assist as much as we can. But generally speaking, no party has any greater degree of leverage, whether it be the revenue authorities, customs and excise, or any of those governmental bodies over the court and so on. I think they would like to, but ultimately, I think we try to keep an even hand among the litigants.
Judge Holmes.
Well, our court fits within the general court system. It's an ultra-specialized court. Because the U.S. is very much a federal system, the tax court has an extremely narrow jurisdiction. It's just some kinds of taxes at the federal level. Even compared to other federal courts, our jurisdiction is narrow. And then, of course, whirling underneath all of the federal courts are 50 state court systems, which are the courts of general jurisdiction over criminal, civil, administrative laws administered by the states. One of the unusual aspects of the U.S. tax court is that our judgments are subject to review by higher courts, but they're subject to review by higher courts of general federal jurisdiction that are geographically organized. So an appeal from a case that I try here in Minnesota would go to the 8th Circuit usually. If it's in California, the 9th Circuit. And that means that those courts can view the tax law differently from each other. And the same decision in a particular case, if it involves taxpayers who are from different states, might go to 2 different circuit courts of appeal where they might disagree with each other. And then the whole system gets unified and uniformity is preserved by the Supreme Court of the United States, which occasionally will take a tax case. A wonderful illustration of this was a single trial produced a single opinion, but it was 2 giant utilities in 2 different parts of the country. One went to the 3rd Circuit, the other went, I think it was to the 11th Circuit. They disagreed with each other about the same opinion written by the same tax court judge. So the Supreme Court ended up granting certiorari and resolving the dispute. That's an unusual part of the federal system. Again, a lot of countries have subordinate or inferior regional governments, but it's unusual for them to have a system of dual jurisdiction that leads to a Supreme Court at the very end of the process.
And Judge Lee, are there any particular pressures from the Korean tax authority or from the public?
No, the one never experiences. The tax authorities, they just party to a case before the court, and then they are very polite. The courtroom, always polite and open a point. Attorney representing them at the courtroom for a very complicated cases as well. So it's never, and then taxpayers, of course, yeah. So it's no pressure actually.
Judge Gafour or Judge Holmes, did you want to make any comments on this particular question?
Well, certainly in terms of pressures being brought to bear, I think principally there may be expectations about the fairly quick delivery of decisions. One of the challenges we have as a court is not, again, and I'm sure this is probably in common with a number of other courts, not always having the degree of resources that we'd like to discharge our responsibilities more effectively. So we have a situation where the judges more or less do their own research, write their own judgments. We don't have access to law clerks or anyone like that to help do drafts and so on. So, of course, and we're sitting in many instances 4 to 5 days a week. So you can see where the weekend goes, as it were, in terms of the writing up of decisions. But having said that, I think I'm fairly proud to say that our delivery time tends to be between 3 to 4 months from the conclusion of a hearing and final submissions to delivery of a decision. And that can be not just in terms of the simpler sorts of cases, but even some of the more complex cases involving interpretation of double tax treaties and so on. So it's something that I think we understand as being an expectation of the judiciary generally to deliver rapid decisions, hopefully those that are reasonably well thought through. But again, I think had we had additional resources, that might help to enhance the work that we do.
Does Trinidad and Tobago have the tradition of oral decisions after a trial?
Yes, it does, and I've tended to give it once or twice. They've normally been appealed, but but having said that, yeah, I mean it's something that we do try to encourage from the perspective of from the conclusion of a hearing. If the parties are happy to make oral submissions then and there, then I think we can sometimes assist by giving a fairly quick decision shortly thereafter.
It would be interesting, I think, on this question to compare the volume of cases. Right. Tax court, when I joined in 2003, had approximately 14,000 cases filed each year with 16 judges, I think we had then. That grew to 38 or 39,000 cases. Now it's down to 25,000. That's per year. So you divide that by the number of judges. Now we have senior judges and special trial judges to help. So it's roughly, 1,200 cases per judge per year. So that means that we have to do a lot of oral opinions. We have to encourage settlements. There is that. On the other hand, in the American system, there's relatively little pressure from either the taxing authorities or the public because they don't know much about us. Indeed, one of my favorite bits of advice from a more senior colleague when I became a tax court judge was to recognize that even lawyers don't know about tax court that much, and that occasionally we would be at bar associations, he told me, and if anybody learns you're a tax court judge and replies, "Oh, you must be very smart, tax law is hard," we were just to nod sagely and say, "Yes." The other thing about tax law in America is that there's not a culture generally of people representing only the government or only taxpayers. Lawyers go in and out of government routinely. There's not an ideology that's pro-taxpayer or pro-government. So it's easier that way compared to, say, environmental law or antitrust law or even personal injury law, where bars tend to become specialized and jealous of their point of view. That's just not the case in the American system as a general matter.
So my final question on this point about the independence of the judiciary would be, and I'll pose it to you first, Judge Lee. I mean, do you think that there might be a need for changes to the current system that could enhance the independence of your court?
As far as I know, there is an ongoing talk about the improvement of the general court administration inside the judiciary, but this has nothing to do with any governmental system. It mainly focuses on how the judicial administration or judicial policy decisions could be done in a more horizontal manner, reflecting various views of entire judges. So it is the other point. So it is, it's in the course of the judicial reform, actually, but it's not about the independence, structural independence and the law, but it's not more the policy sense. It's a policy sense. Yeah.
And Judge Gafoor, I think you were mentioning when we were talking that perhaps you would like, or there should be more transparency, I think, in the nomination or in your appointment process.
Yeah, I mean, I think that would always be welcome because, I mean, you want to instill confidence by members of the public as well as the corporate sector that the judges who are going to hear matters hopefully have the necessary competence, but also sufficiently impartial as not to give way to any other extraneous considerations. So that process, I think, I mean, I hesitate to use the word tainted, but I think it could be improved by virtue of the appointment process for the other member judges. As mentioned, the chief judge or the chair tends to be, that process tends to be fairly impartial, and of course, as has been suggested, you would want to ensure that you would not necessarily find yourself with any degree of conflict of interest. But we have had situations because of the appointment process of the member judges where they've had to recuse themselves from time to time. As you can well imagine, with a relatively small bench, that can be problematic because it allows a party to object to someone hearing a matter if they think they may be compromised, or indeed even if you, we normally sit as a panel of 3, but if, for example, one judge has to be recused for whatever reason, then the parties actually are entitled to object without giving any reasons as to why you shouldn't hear the matter. So that has been a little bit difficult for us over the years, but thankfully the parties, I think, have also been more understanding in more recent times, so that we've tried not to we've tried not to ensure that that doesn't stymie the work of the court in any way.
Yeah. I can't think of anything that would increase the independence of our court in any positive way. But it's important, when I reflect on this in the context of other countries being represented here, how much depends on custom in the American system. You know, theoretically, the president can remove a tax court judge, and his decision would be effectively unreviewable by any court. If he didn't like our decisions on substantiation, or somebody shows receipts that he would prefer not to have to show receipts or something, he theoretically could remove us. That hasn't happened once in 80 years that the court's been in existence in one form or another. You know, theoretically, Congress could say, we don't like the way you're making decisions, we're going to slash your budget in half. It doesn't happen. They could say, since our salaries are controlled by Congress, we're not going to pay you what Article 3 judges, that means judges who have courts of general federal jurisdiction, get. We're going to pay you on a piece rate basis or something. We're not going to give you, we're going to cut your salaries in half because we don't like what you said about the IRS in the most recent decision you made. That never happens. It's theoretically possible, I suppose, but there's such a strong culture of judicial independence in America that it just never happens. But it is a matter of custom. It's deeply held custom, but it is a matter of custom.
Very good. Thank you. And let's step away from talking about the independence of the judiciary and going a little more into the weeds with respect to both of your presentations. And I wanted to focus first about taxpayer rights. I do know, so Judge Holmes, yesterday there's been a lot of discussion, or at least high-level discussion, about our TBOR and so the relatively recent, passage of 7803A3. I know, so Justice Gafoor, it's my understanding that your nation, Trinidad and Tobago, does not have any sort of statutory or administrative TBOR. And what are your thoughts about not having that?
Yeah, I mean, I think that, one of the benefits of coming to these sorts of conferences is the exposure to the practice of other states. So I think that is certainly something that we would want to see happen. But, I mean, again, with so many of these issues, it depends on the government of the day trying to take forward that legislation. So we can suggest possibly areas of reform, but ultimately it would be dependent on the government. I mean, I think what would be helpful is if you had taxpayers, organizations that could campaign for that, because I think there's a limit as to what the court itself could do. But having said that, I also think that what we have tried to do is to publicize areas and talk about areas of reform that I think could be useful. So to a large extent, I would want to see some of these developments that, of course, obtain in Canada and the US and so on, coming into being there. But at the same time, the process also seems to be a little bit too slow, unfortunately.
And I think you've mentioned that you had, or maybe some of your colleagues, you've had cases where a taxpayer does make the attempt to assert a violation of rights. Yes, I think you were talking to me about that. Can you talk a little bit about that, so your experience?
Well, I mean,
how did you deal with that?
Yeah, I mean, some of it really turns on whether or not a taxpayer understands what the court can or cannot do. So we've certainly had persons coming to court and asking for more informal procedure to be used, or for some other process which perhaps isn't permitted under the court's current legislation. So that really requires perhaps us taking them through the process and trying to explain exactly what are the parameters of our jurisdiction. And we're very happy to do that. But one of the issues is that I think there are greater expectations by taxpayers in terms of what courts can do to protect them and their rights. And I mean, of course, in keeping a level playing field, between the revenue authorities and litigants or taxpayers, the court, I think, has to tread very carefully in ensuring that it isn't perceived in any way as being likely to favor one party or the other. And I believe we've managed to do that over the 50-odd years we've been around. and of course it's a tribute certainly to my predecessors in office, because I think those who are appointed are mindful of the fact that they're appointed in a judicial capacity and seek to carry out that mandate as effectively as they can. But, there's always room for improvement, and one would want to see a greater degree of dialogue. I mean, I've mentioned perhaps the use of mediation as being one process which might help to avoid the burden of going through a trial process. And I think more and more I see the benefit of that in terms of resolving disputes.
And Judge Lee, has your court had any opinions addressing you talked in your in your paper about the taxpayers' rights, which is chapter 7-2.
Yes, we have we have statutory Bill of Rights, taxpayer rights since 1997, and we have some cases dealing with the arguments, and some of them were successful, especially for the violation of a prohibition of a duplicate audit, duplicate tax examination investigation. So it's a hot issue, and that a lot of case laws is accumulated actually at the moment. It's very interesting and remarkable. Actually, it's sometimes taxpayers win, sometimes tax authorities win. When there's the border cases, we have a lot of cases, whether they have like obvious evidence, whether one of the exceptional categories allowing the double audit. Just always is a hot issue.
And that's the Article 81.4.
Yeah, add 1.4, add paragraph 2. Yeah.
I do have to say, just for everyone's perspective, I was reading through the taxpayers' rights, and the previous article, which is Article 81.3, sort of gave me a little bit of a laugh. It's called Presumption of Taxpayer Sincerity. Yes, any tax official shall presume that a taxpayer is sincere and the return, etc., submitted by him is true, unless he falls under any subsection, one of the subsections, which is like for evasion, a false transaction. That sort of gave me a little chuckle. we don't have that here in this.
Actually, I think it's quite the cultural.
That hasn't been covered.
The Asian finds cultural thing as well. We think we presume the mutual understanding for the sincerity kind of.
We don't have that either, in the sense that sounds like a wonderful provision, though I'd like to adopt that. But generally speaking, the onus is on the taxpayer to try to disprove the assessment that has been raised against them, and sometimes that can be a heavy burden. I think one of the other rules that was brought in and has given rise to some degree of litigation has been the exclusion of evidence, particularly where something goes to trial. So when the parties are engaged in discussions or negotiations, they're fairly free to produce whatever documents might be supportive, particularly of the taxpayer's case. But if the matter does go to a full-blown trial, then the revenue sometimes can use that particular rule to seek to exclude the evidence unless it had been produced to them when they were coming to the administrative decision. And that has given rise to some issues that have arisen before us.
Also, one more addition for that. Actually, in Korea, the burden of proof is on the tax authorities, not the taxpayers, because of the mutual understanding of the sincerity.
That's interesting. Judge Holmes, do I make some
taxpayer Bill of Rights. I got to say something.
Be good now.
Well, she's right in front of me, But we have a Bill of Rights now that includes these general sort of airy general right, the right to be informed, the right to quality service. I'm going to take the radical position that these aren't rights in American law. They're sort of aspirations, maybe a distillation of what we think. The right to be informed. You can't come to tax court and say, I wasn't informed. We actually have a case on that now. What you do have a right to is a notice of deficiency that explains what section of the code you're charged with having underpaid or underestimated your taxes on. The right to quality service, you can't come to tax court and say the IRS was rude to me and expect to get anywhere. What you have is a right to contest your tax in an impartial tribunal. What you have is a right to be informed of what the government thinks in some concise way. That's the notice of deficiency. You have the right to present your evidence. But these taxpayer Bill of Rights that we've been talking about for 2 days or so are not rights in the sense that they're judicially enforceable. And that's an unusual use of the term rights then. What they are is a distillation of what all these other complicated provisions in the tax code give to people who want to litigate about their, the proper amount of tax that they want owed. You have a right to challenge the position of the IRS and to be heard. Well, yes, but that doesn't mean you can stand up and ignore the rules of pleading or ignore the time limits on filing petitions or filing notices of appeal. With the protections to American taxpayers are in this complex web of statutory and customary practice. They can't be distilled into 10 rules or taxpayer rights and then have those rights become an independent source of obligations by the government to taxpayers. Instead, what you have is a complex web of statutes, regulations, customs that taxpayers have to negotiate. They can't just appeal to general principles and hope to get anywhere with a judge.
Well, I think I...
Now I've ruined your day.
Right, well, no, you have not. I think I do. I agree with you with respect to it in the context of a deficiency case. Because as many of you know, our standard of review is de novo. We don't look behind the notice of deficiency. That's a long-held principle, the case of Greenbird's Express. But I do perhaps push back on you in the context of, say, CDP case or whistleblower case.
In what way?
Well, where the standard of review is not de novo; it's abuse of discretion,
That's
and
right.
so taxpayer makes the argument that in my CDP case under 7803A3, my rights were violated.
That's a bad argument. You'd have to say what right? There again, even in something as
I don't know, the right to be informed, the right, my privacy rights were violated during the CDP process.
Well, you're going to lose on that because you don't have a right to privacy in the CDP process if you want to compromise your tax bill on the basis that you're too poor to pay the taxes. You have to give the IRS the financial information that shows that you're too poor. They won't take you at your word, nor should they. And if you say, my rights were violated, well, what right do you have? You have the rights that are given to you in the Internal Revenue Code. You don't have some airy-fairy, loosey-goosey source of rights other than what is in the written law.
Or even the right to quality service. So taxpayer... for example, taxpayer lives in Las Vegas and asks for the CDP hearing, to be held there, and yet it was conducted in Seattle or California.
That has actually happened. And if there is a regulation that says that you're entitled to a hearing in the IRS office closest to where you live, then you have a right. The regulation gives you that right. But you can't come up with your own theory of rights that are not in a regulation or a statute or the Constitution or the rules of a court. So to that extent, you are protected, but you can't invoke the Taxpayer Bill of Rights like you can invoke the Bill of Rights that's part of the Constitution. So to that extent, I'm throwing cold water on everybody.
Well, I think it's a stay tuned. Well, and in fact, actually, before the Moya decision, which was just a few months ago, our colleague, Judge Lauber, in a TC memo opinion called BLETSAS, BLETSAS, which was TC memo 28120, because I did a search on Lexis just for 7803A3, and this came up. This was a CDP case. She raised the issue she raised the 7803A3 issue. Her right to be informed and her right to privacy were violated during the CDP process. However, our colleague punted on that because she hadn't raised it below during the CDP hearing or in her petition. And so therefore, under our rules, Rule 331, B4, we or the court or Judge Lauber could not reach that issue.
But sheer formalism. There's a right and it has no remedy. Oh, my heavens. No, the point is that in any reasonable legal system, you can't appeal to general principles. What you can do is appeal to the words of a statute, the words of a constitution, the words of a regulation. And if you start appealing to general principles, other than perhaps a way of helping to interpret ambiguities in the words of a statute, or words of constitution, or the words of a regulation, you get nowhere.
I see a reviewed opinion coming. That's all I'll say on that matter. With the last 15 minutes that we have, I did want to move into some of the practical things that each of our courts have done to accommodate taxpayers, to protect their rights, to increase access to justice. And so I'll pose the question with you first, Judge Gafour. So do you do have a fairly significant self-represented taxpayer population in your courts? And what steps have you done, or you can maybe go into a little more detail from your paper?
We do. In fact, I think that while one may be tempted to, and I think certainly the business community seems to think that it's primarily, the court exists primarily for their benefit, and of course it does to a large measure, but we have a significant number of self-represented litigants, and I think they come not necessarily being fully cognizant of the rules of court, rules of evidence, rules of procedure, and so one of the things that we've tried to do is to ensure that we have some publications that are available to guide them through that process. If it is that they need some assistance in understanding some of the technical terms, again, we can try to assist insofar as that doesn't cause us to have a conflict in terms of having to interpret particular rules and so on. So from that perspective, we try to be as helpful as we can without, shall we say, leaning too much in favor of favoring one party or the other. Certainly we have registry staff who are well versed in guiding parties through the process and observing time limits and so on. And generally speaking, again, as mentioned in my presentation earlier, our library facilities and other officers who exist there, certainly such as the registrar, try to guide parties through the challenges that they may have in presenting a case. So, but I mean, having said that, even if parties may not fully observe the rules insofar as it doesn't cause any injustice, we try to ensure that there is some degree of flexibility in terms of how those rules are applied, without, of course, trespassing into anything which is improper or illegal. But I think the idea is that parties must feel comfortable that they're getting a fair hearing. And I think by and large, the feedback that we've had so far seems to indicate that they feel reasonably comfortable with that. So at least I hope we're doing a reasonably good job in that regard.
And Judge Lee, what steps or measures, meaningful measures, has your court taken to accommodate taxpayers?
No. Okay. As I earlier explained, it is not common to see a self-represented party in tax litigation compared to other civil cases, partly because I think it's tax cases at the court very tricky, difficult, technical, and then the other I think reason is in Korea there is just administrative relief such as adjudication by the tax tribunal, which must first be undertaken before bringing a case into the judicial court. Anyway, but there's some represented taxpayers we have, and then they can get information and trial procedures and required documents, every document from the code step and the website. We have brilliant websites for that one. And then also the court can decide on his petition or our own initiative to endorse the legal aid, including expenses for the legal counsel for the taxpayer. Yeah.
Yeah, we have a giant number of pro se taxpayers in our court. It's more than 75% of our cases are pro se. To help them, we have an active pro bono program with volunteer lawyers. We have a network of low-income taxpayer clinics for those who don't have the means to represent themselves but could benefit from a lawyer. We have roughly 40% of our cases now are so-called S cases, or small cases. So if you're below $50,000, the stakes might be too low for a lawyer to get involved, except on a volunteer basis. And for those cases, we have relaxed rules of evidence. We also don't allow appeals from those cases, which reduces the stakes of the IRS to fight them. for fear that a bad precedent might be created in a case where you have a sympathetic but perhaps inarticulate taxpayer representing him or herself. On the plain language side of things, in the last 15 years, there's been an immense amount of effort on the part of my colleagues to have a website that people who are not legally trained can understand. We have we have videos of what you can expect when you come into tax court. We have explanations of what a summary judgment is, because the government so often moves for summary judgment. But perhaps the most important, I think, experience that I've had is that in the American system, which is so heavily adversarial, the idea being you have a lawyer on both sides representing the client, in tax court at the trial level, we very, very easily and I think universally slip into an inquisitorial model. If you have a pro se taxpayer whose only witness is himself or herself, the judge is going to start asking questions to make sure that the record, such as it is, can be as complete as possible so that the law which the judge is in possession of can be accompanied by facts that actually get presented. Most people who represent themselves are not going to have exhibits in consecutive order with little stickers on them. They're not going to be able to know the magic words to get something admitted into evidence. They're not even going to know the, 26-part test for distinguishing an independent contractor from an employee or whatever it is. And so if the judge does not start asking questions in that case, the record will be barren. And that was something that was unexpected to me because, of course, when I was a real lawyer, there was a lawyer on every side in every case that I was involved in.
But then how much is too much, do you think? When does it become you create a conflict?
I draw the line at making sure the record is complete. If it looks like there will be an interesting legal argument or a contested legal argument, if the taxpayer is of means, I'll strongly recommend they go and get a lawyer. In cases where there's going to be something that's very difficult, I'll ask a low-income taxpayer clinic if they can do it. If not, I'll informally ask somebody in the private bar to do it. An example of this was a $5,000 case that appeared to have been the first case in the American tax system involving the taxation for the sale of eggs. You know, those egg donors, young women who do that? She was getting like $5,000 per procedure. It was not going to, you can't afford a lawyer for a $5,000 case. But the issue was so interesting to people, it was easy to get a local lawyer who was pretty good to represent her and to let it be known that I would accept amicus briefs in this from academics who've been writing about the subject. And you end up getting all the arguments that way on the law. The facts of the case, you know, you patiently ask the young woman what she went through, make sure the contract that she signed is in the record, that kind of thing. That's fair enough. But I wasn't going to suggest arguments to her on whether human eggs were long-term capital gain, short-term capital gain of sale of services. She needs a lawyer to do that. So.
Yeah. Can I just add that one of the issues that sometimes occurs is when self-represented litigants come to court and they bring along someone like a professional advisor, an accountant or someone like that, and they might anticipate or expect that that person could formally represent them in terms of the advocacy side of presenting the case. And we have to kind of gently seek to explain to them that the accountant, unless they have some legal qualification, cannot actually represent them in that regard. But certainly we've not objected to that person literally sitting behind them and giving them some guidance, as long as they themselves don't necessarily present the case itself. But the issue that has perhaps occurred even more urgently or more, importantly than that, is people who decide to form a company. It's remarkably easy to set up a company, corporate entity in Trinidad and Tobago, and then coming along and seeking to represent that company themselves. and that, of course, is because they don't always appreciate I suppose, esteemed principle that a company is a separate entity from the individual. And to that extent, we, again, try to encourage them to seek legal representation. In fact, we insist on it.
That is a good example of how converging English-speaking systems that owe their debt to the UK end up being. We got around that in the case of small corporations by letting an officer of the corporation represent itself. But that's unique to tax court. That's not generally the case in the States. And yes, I too have had the whispering accountant. It's so much, the accountant ends up knowing more about the case than everybody else, but he's not a lawyer, he's not a member of the tax court bar. I want him to be able to help his client. So yeah, whisper in the air.
Exactly.
Do you have whispering accountants in Korea?
Yeah, the judges in Korea, we want you to be kind enough.
Well, actually, going to the whisperer.
Yes.
What about in the context of, because I think your court, and you are a certified mediator.
Yes, that's
and
correct.
in your court does a lot of mediation, and in that scenario, would you allow the whisperer to participate?
Well, I mean, that wouldn't necessarily be mediation in the traditional sense of having a more informal process, which doesn't necessarily examine rules of evidence procedure in that way. What we tend to do is to encourage parties to engage in discussions, negotiations. One of the problems with that is that sometimes those can become unduly prolonged, and so therefore we've had some cases that have been in the system for a really long time. So what we do try to ensure is that if we've allowed a sufficiently reasonable period of time to engage in discussions between the revenue, customs, whichever body it may be, and the taxpayer, we tend to then encourage them to put the matter down for trial. And sometimes fixing a date for trial can actually have a very salutary effect in terms of ensuring that they actually can compromise the matter much more quickly. I mean, I think certainly one memorable case that springs to mind is a matter that had been going on in negotiations for a ridiculously long period of time of about 5 years. And I think shortly after we listed it for trial and the trial started, they settled it over lunchtime. So sometimes I think the court does have to step in and to say enough is enough. You've had your chance to try to resolve it, and it's time to get on with it.
Do you also have multi-year or multi-taxpayer issues where you're trying to maneuver multiple years into a single proceeding or compromise?
All the time. Sometimes those are consolidated, and they try to deal with the, if you have the same issues arising in multiple cases, they tend to be tried at the same time. And that can be a little bit problematic, because where you think negotiations are proceeding in a case that's been in the system for a little while, and then new cases are filed, they sometimes want to have that treated with it as well. So that can be a thorny issue.
And Judge Holmes, have you had, so far in your 15 plus years on the court, the opportunity to do any mediation? I do think, because we have rules and procedures regarding that, I think it's overlooked, our tax court rule 124.
No, formal mediation, no. But like most of us, I think, Judge Ashford, we get on the phone and we try to encourage people to get together and settle and get the information they need so that they can reasonably evaluate the strength of each other's cases. That's often a prelude to settlement. Although, I guess part of my mediation practice is to say, no, you're not getting a continuance. It's good to know that that's a multinational, international phenomenon.
Yeah, I mean, we're a mediation agency, I think, as was mentioned. And one of the things that, of course, we haven't been able to do successfully is to persuade the revenue that they should engage in mediation. In fact, recently we were looking to engage in and update our legislation to take that forward. And generally speaking, the appellant taxpayers didn't seem to have a major problem with that, but the revenue did. So it may be that we've got to engage them a little bit more and try to encourage them to see the benefits of utilizing that process to resolve, especially the smaller disputes.
Well, I think we've discussed some of this particular question. Would anyone, particularly Judge Leah, and Judge Gafour, an opportunity to talk maybe a little bit further about equitable or procedural accommodations? For example, Judge Gafour, particularly with a self-represented taxpayer, do you and/or your colleagues, liberally, grant continuances?
Yeah, I mean, I think generally speaking, if someone really feels that they're a little bit out of their depth, and sometimes that can happen, especially when they're up against a professional on the other side, and of course the revenue authorities are invariably represented. In fact, they tend to have to be represented by a professional attorney. And someone comes along and they need to get an adjournment or continuance, as you say, then, we've generally speaking tried to facilitate that, especially where, they've reached a juncture in their presentation or in their case where they may may need some assistance with research. As Judge Holmes says, I mean, one of the issues that may occur is where, they really need to have some greater degree of guidance. And if we can encourage them to seek legal representation and they're able to afford it, certainly we try to encourage that. But in most instances, the self-represented litigants have actually had a pretty good record of success before the court. So I hope that encourages them in some way as well, too.
Judge Lee. Okay, very good. Let's see. Let me make sure we get through these questions. Is there a conflict if and when a judge eases the rules or tries to assist a self-represented taxpayer? Can a judge remain impartial and still assist with the self-represented taxpayer? Judge Lee?
Yeah, the impartiality is crucial to the civil proceedings, so it's the same in the tax litigation. So there's a limit. Yeah.
And in Korea, do you all have a code of judicial ethics?
Yes,
that you are
so
bound
we
by?
have. Yeah.
Okay.
Yeah, we don't have a specific code for the tax court. There is a broader code of judicial ethics, which obviously we adhere to. But in terms of ensuring that the court continues, I hope, to enjoy the confidence of all of the parties, I think there's a limit as to how far you can take things in terms of being unduly flexible over the rules. So, a lot of what we try to do is really by way of informal guidance during the course of a hearing, and of course, off the record if they need some assistance in terms of the procedures for filing documents and so on. Certainly, as alluded to in terms of the U.S. tax court, we try to ensure that they can get the benefit of that advice. But some people just like to have their day in court, and I think they like the idea of facing down the revenue authorities that they think have been a little bit unfair to them, at least from their perspective. So from that point of view, we don't have a problem with that. Sometimes people do need to vent before they can truly resolve matters.
Any other comments from the panel on this question? And so I think my